Harrison, presenting oral arguments to the Second Circuit U.S. Court of Appeals regarding our 9/11 case on the citizens' First Amendment right to report crimes to a grand jury and a little bit on the secrecy limits on grand jury proceedings. And Mick just got done with that literally within the last half an hour. So how are you feeling about it, Mick?
I feel good about the argument, Gene. We had some good questions from the court, from the judges, 3 judges on the panel. I got the impression they were listening attentively to arguments from both sides. It's a very short argument. For folks who don't know, you get about 10 minutes on each side, so it goes pretty quick. We were allowed a couple extra minutes for my argument. I actually went over time, and the judges were courteous enough to let me answer a couple more questions, which was good. I think, it's an important question for folks who haven't followed it about whether, and it's not, for me, it's an easy answer, but for judges, I think they're surprised to have to decide the question, which is, do citizens have a right to, under the First Amendment, to petition a federal grand jury, like we did with the Lawyers Committee and architects and engineers and about 2,000 others, including some 9/11 family members, some ground zero responders. And the reason it's, I think, seems like such a surprising question for the court is the U.S. attorneys have been getting by for, I don't know how long, decades probably, with pretty much controlling what grand juries see as a matter of practice, not necessarily as a matter of law. And so when, a citizen or a citizens group, as here, insists on exercising the same First Amendment right that clearly the courts recognize that we have regarding every other branch and component of government, there's no debate about that part. When we insist on exercising it regarding the federal grand jury, the courts are surprised because they haven't had to deal with that. And U.S. attorneys, I think, don't want to be bothered with the burden it imposes on them of having to deal with the public and the concerns of the public in regard to the grand jury. But every other federal agency has to do that. You can petition the president, you can petition the Department of Transportation, the Department of Energy, the EPA. All those agencies have to deal with public submissions. They've all found ways of managing it. So, this is strangely the first time the courts have had to come to grips with what do we do if citizens start petitioning federal grand juries?
Yeah, I appreciated the one, forgive me, the one female judge leaned forward and, I'm assuming leaned forward and asked, she was perplexed by your approach that, do you realize what kind of burden, or not burden, it wasn't the word she used. And you said, well, this is something I think the court should approach. And
yeah, I think it may have been Judge Lee. I'll have to check the names, but the question was how do we manage it as a practical matter if citizens start doing this? And the answer is, well, the courts have come to grips with the demands of citizens, other agencies have, and have found ways to manage the workload challenge. But the law is clear, including a Supreme Court decision I cited from 2021, that if you do actually end up with a conflict between a challenging burden on an agency, challenging workload or inconvenience, versus respecting the exercise of constitutional rights, the constitutional rights win.
right.
The agency just has to find a way to deal with the burden.
I want to get this one, if it plays. I have one clip where a judge had asked you, it kind of confused me. And he's making a statement that the Constitution doesn't guarantee that the courts have to hear a petition. Let me just play this if I'm.
There is no First Amendment right on the part of the petitioner to have the government listen to the petition. You can petition, but the government may or may not act on it. I understand Your Honor's point.
So.
Yeah, I remember that. I think that was Judge Walker. And a lot of citizens will be surprised to know that technically the judge is right about that point, on terms of how the law stands at the moment. Maybe not how the law should stand.
Okay.
But on the other hand, it shouldn't be. Well, that's Jane calling me. She's going to have to wait. So the right to be heard means more than the right to submit or the right to petition. It means the right to get a response,
Right.
the right for the agency to listen and pay attention. We're not even asking for that in this case, strangely enough. We actually have confidence in the grand jury that once it sees the petition, it will pay attention to the petition, read it, and then proceed accordingly. But we're not asking or demanding that the grand jury agree with us in the petition. We're not asking they give us a written response. We're just trying to make sure it gets delivered.
So what he said right there wasn't. Oh, that's confusing.
It wasn't
He-
on point for this case.
I guess I'm asking you. He wasn't trying to say that we don't have a right to have these 60 exhibits handed to a grand jury in the Constitution, or was he?
Well, you'd have to actually ask the judge that question to be sure. I don't believe he was.
Okay.
I think the judge understands, and he may have said something in the rest of his question to make it clear that the right to be heard means the right to get a response, the right for the agency to read
Oh,
what you submitted, the right to have the agency listen. I mean, when you think about the meaning of the word heard, it's different to say that you spoke a word to someone else than to say that they heard it. Okay. In our petition, litigation is about delivery of our petition. It's not about whether anyone reads it. And that might seem strange, but we don't have a concern about that end of it because we have confidence the grand jury will in fact read it. It's a compelling petition. It's on a very important issue. I mean, if you were one of the 18 to 23 grand jury members from the public and you got a petition on, what caused most of the deaths on 9/11, would you read it? We're pretty sure they would.
yeah. Right.
We just need to get it delivered.
Okay. How soon of a response or how soon could we hear a response, do you think?
Well, it could be tomorrow. I don't expect it to be tomorrow. It could have been today when the judges said they would take it under advisement. That means they're not deciding it in the moment. Typically, they take a few months actually to decide after briefing and oral argument. So that would be a best guess.
So if it sides with us, we would see or hope to hear from some type of movement with the impaneling of the grand jury. If it goes against, then you would appeal and go to the Supreme Court.
Well, there is an option to petition the Supreme Court to hear the case. There is an intermediate option that a lot of folks don't know about, and that is petitioning every judge in the Second Circuit, what we call en banc, to hear the case. This is a 3-judge panel. And if you get a decision that is negative from a 3-judge panel, you may ask the panel to reconsider, or you may ask the entire court, which is, I don't know how many judges now in the Second Circuit, 15, 20, 25, I don't know. You can ask the entire court to hear it en banc. It isn't heard en banc very often, but it's heard en banc on important issues, and this is an important issue. So it might happen. That would be a decision the clients would have to make, and we, I would advise them on it, but it would be their decision to make.
Thank you for the update. You have anything else for anyone else?
I will say for your listeners that I will be talking in more detail about the argument in the case at 9 p.m. Eastern today with Kevin Barrett on Kevin's radio show, and we'll be talking about it at length again right after Kevin's show at 10 on the other side of the news from 10 to midnight. So folks are welcome to tune in to those programs. I don't know about Kevin, but I believe the other side of the news may allow people to call in questions.
Okay.
Thank you, Gene, for the opportunity.
Yep. Thank you, Mick. Great job again. Have a good one.